Hello, I'm Habiba. I'm going into the part two of our discussion on competency, compatibility, and privilege. And today I want to proceed on with the issue of competency, and we'll focus particularly on competency of a child witness. So, in the last lecture, we have looked into the concept of competency, compatibility, and privilege. So we understand that when we deal with competency, we are basically asking the question whether the person understand the question put to them and whether they are able to give rational answers to those questions. And under Section 118 of the Evidence Act, it identified that all person can testify. So everyone are competent to testify if they manage to answer the two questions just now positively. And under Section 118 of the Evidence Act, basically highlighted uh, two persons that may have issues of competency. That is when the person is extremely old or the person have disease of the body and mind. So that is a situation where the person may have competency issue. So when we talk about competency, so basically, the law on competency here is under section 118. So under section 118, it states that all persons are competent to testify, and as long as they understand the question and able to give rational answers to those questions. Bear in mind that if you are dealing with adult witness, competency is presumed. So if competency is presumed, there is no need for you to make inquiry to determine whether the person is competent or not to testify. So when we deal with competency of a child, so basically, if you look at section 118, section 118 has taken away the word tender years. So because of the phrase tender years being taken, so a child is no longer regarded to be the person that have competency issue. Having said that, when you deal with evidence of a child, competency of a child witness is governed by section 2A of the Evidence of Child Witness Act 2007. All right. So if you look at the law, when you deal with evidence of a child, let's see here. Okay. When you deal with competency of a child, it is governed by the Evidence of Child Witness Act 2007, and this is effective on the 3rd of March 2025. And basically, when you talk about a child, you are talking about a child who is 18 years of age. And this is actually mentioned under Section 2, Subsection 1 of the Sexual Offences Against Children Act 2017. Now, the amendment made to the Evidence of Child Witness Act 2007 here has also resulted in Section 118 being amended, as well as SOACA 2017 being amended, whereby in SOACA 2017, Section 17 and Section 18 has been taken out. So the law on competency of a child now is governed by the General Law, Section 118, as well as Section 2A, 2B, 2C, 2D of the Evidence of Child Witness Act. So now let's look at Section 2A. So we read Section 2A. Section 2A of the Evidence of Child Witness Act talk about the competency of children. All child witnesses shall be presumed to be competent to give evidence in every proceeding. So basically, if you look at the provision of Section 2A, this is the word used, shall be presumed. So basically, Section 2A, subsection 1 provides you with presumption that child are supposed to be competent to testify. And the nature of presumption that is invoked on the child evidence is, I believe, by the use of the word shall here, this is a presumption of law. Now, what does this, how significant is this amendment to the law? So basically, what happened was that, right, prior to the incorporation of Section 2A of Evidence of Child Witness Act into the law, we have the law on child evidence, whereby the law basically reflect that child cannot be trusted. A child witness cannot be trusted. The law has stated that why are they not to be trusted? Because children tend to fantasize. So children tend to fantasize. That is why, say for example, you're staying in a house, a 3-story house, somewhere up the hill, and your house is basically alone there. You ask your sister who is 7 years old. So you have a sister who is 7 years old. Yeah, you stayed in a 3-story building and your house is alone there on the hill. You ask your sister to go down and get you a glass of water. She will be very much reluctant. Why is this particular child reluctant? Because she will believe that there's something lurking behind walls. Yeah. So they basically thought that, well, they could be go somewhere. So basically, this indicates that children tend to fantasize. So if she wants to go down alone, she will switch on every light in the house so that it's going to be bright. Then she will get through the water. So this is an indication to reflect that children tend to fantasize. They believe things which are not there. Because of that, the law, the old law, reflect that children cannot be trusted. They tend to fantasize. Because of that, this bears on issues of his competency to testify. All right. However, this proposition of law is aimed to be changed by the incorporation of Section 2A, Sub 1 of the Evidence Act, of the Evidence of Child Witness Act, because Section 2A, Subsection 1 basically made a presumption that children, whenever they testify in the court, they are deemed to be competent to testify. Now, by the use of the word shall just now, it connotes maybe this is a presumption of law because of the words shall. So if it is a presumption of law, so it is not what people think, it is the law that presume it to be like that. So, but the presumption in Section 2A, Subsection 1 here is a rebuttable presumption, meaning to say that if the court finds that there is some competency issue, or if the defense counsel, for example, has doubt as to the competency of this particular child, they may question and challenge it. So in that case, the court need to do an inquiry to determine the competency of a child. So when you read Section 2A, of course, that is presumption. The presumption that children are supposed to be competent witness. Now, what is the aim of having this presumption saying that children are competent? So this is, if you look at this one, this is contrary to the previous proposition to say that children tend to fantasize, so they are basically have issues of competency, they have problems on believability. So basically, when you have Section 2, Subsection 1 incorporated into the Evidence of Child Witness Act, you make a presumption, you start looking at children positively. Rather than having a negative in your mind, children are not to be trusted, we now assume that children are competent to testify, rather than looking at them initially not competent. So now the law is actually asking us to look at the children to be competent witness for the purpose of making the most of evidence given by the children. So the standing of whether the child should be trusted, whether they are competent or not, become number 2, because the idea is that we need to look at what the children are saying. So basically, when you talk about a child, children, when they testify in the court, okay, they can give sworn and unsworn evidence. So when you deal with matters of children testifying, yeah, there are always two issues. Number one, is the child competent? Yeah, is the child competent? That will be number one. So this particular question have been answered positively by looking at section 118. If the child can understand the question put to her and able to give rational answers to the question, so basically you apply section 118 and you apply the principle in Tajuddin bin Saleh. If the child able to answer the question and give rational answers to those questions, the child is basically competent. This proposition of the general law is further strengthened by section 2A, sub 1 of the Evidence of Child Witness Act, which the law presumes that children are competent witness. So basically, if you read section 2A of the Evidence of Child Witness Act, you find that all child witnesses shall be presumed to be competent. So it has started in a positive note. So if you have a child, so here you have, for example, the child witness here, who is 7 years old. You ask the question, okay, he's able to give rational answers to the question, then the child is competent. The second question that you have to deal when dealing with a child is this: should the child give sworn or unsworn evidence? Or unsworn evidence. Should the child give sworn or unsworn evidence? Now, what is sworn evidence? What is unsworn evidence? Sworn evidence is where you take evidence. So this is based on the Oath and Affirmation Act. Sworn evidence is where you take up, you sworn your, you take a, you swear upon maybe a holy document, for example, the Quran or the Bible, to say that you will not lie. You are telling the truth, nothing but the truth. So you are making a sworn statement. You promise to the court that you are going to tell the truth. Now, what is unsworn evidence? Unsworn evidence is where you are giving evidence in the court without having you swearing on the holy document. So that is actually unsworn evidence. So when you deal with evidence of a child, so a child witness can give either sworn or unsworn evidence. Now, what did the law say about child here giving sworn and unsworn evidence? So if you look at the section, yeah, if you look at the section of the Evidence Act, now, basically, if you read section 2A, subsection 2, so this is actually the proposition to reflect that a child witness is not competent to give evidence in a proceeding if the court finds, based on inquiry conducted, so the child is not able to understand the question put to them and give rational answers to those questions, so she is not competent. So basically, section 2A, subsection 2 here is confirming the proposition in Tajuddin as well as section 118. Because if you don't understand the question, you cannot give rational answers to those questions, so you are not competent. So if you can answer this one positively, then you are competent. So if you are competent, what kind of evidence will a child give? So you look at section 2B. So if you look at section 2B, subsection 1, a child witness shall give evidence upon oath in a proceeding if he has attained the age of 12 years and understand the nature of an oath. So basically, under section 2B of the Evidence Act, a child, yeah, so hold on. So if you have evidence of a child, the question will be, should the child give sworn or unsworn evidence? If you refer to section 2B, subsection 1, So basically under section 2B, subsection 1, if the child has reached the age of 12 years old and the child understands what the nature of an oath, the child should give sworn evidence. So basically, section 2B has kept the age of 12 years old will be the age, will be the age where the child is mature enough to give sworn testimony or to give evidence on oath. When you read into section 2B subsection 2, section 2B subsection 2, let's look at 2B subsection 2. A child witness who has not attained the age of 12 years old or does not understand the nature of an oath may give evidence not upon oath in the proceeding. So basically under section 2 subsection B here, okay, under section 2 subsection B here, you are dealing with a child who is below 12 years old, and the child here does not understand the nature of an oath. However, even though he might not understand the nature of an oath, but he understands the responsibility or the obligation of telling the truth, and he should give unsworn evidence. So what do we have here? Under this provision of the Evidence of Child Witness Act, the law has put the age of 12 years old to be the age where the child may have sufficient maturity to understand what oath is. However, because maturity of children basically develop maturity differently. So you may have a child who is 12 years old, but living in a very protective environment. So basically the level of maturity may be different from someone who is 12 years old, living alone, have to care for maybe 5 or 6 younger children, younger sisters or brothers. So basically you have these two children of the same age but different level of maturity. So because of that, section 2A, section 2B, subsection 1 and subsection 2 recognize the fact that children have different level of maturity, therefore you have this distinction in the law. However, section 2B, subsection 1, they put a year, 12 years old, to be the date where the child may be mature enough to understand what oath is. So that's why in section 2B, subsection 1, if you have a child of 12 years old and understand the nature of an oath, so she should give sworn evidence. If you have a child who is below 12 years old or even 12 years old, but do not understand the nature of an oath, but understand responsibility of telling the truth, he or she should give unsworn evidence. So this is the proposition made under the Evidence of Child Witness Act. Now, is this proposition the same or different from what we have under the old law? So basically, under the old law, we don't have this presumption. So under the old law, children there's no such thing as presumption that the child are competent. So basically, under the previous law, there is no age invoked by the judges to reflect, okay, this age you are mature, you give sworn evidence. This age you are not mature, you understand what you don't understand what oath is, but you understand the duty to speak the truth, you give unsworn evidence. So basically, previously, not even a single case law basically put down the age in which the child should give sworn or unsworn evidence. What happened was, in the previous case, the competency of a child to testify whether the child should give sworn or unsworn evidence is determined on case-by-case basis. So that is why you have maybe pool of cases where reflect that those who age 8 years old should give unsworn evidence. This one is upon examination, upon inquiry made to determine the maturity of the child. So you have pool of cases where you have children aged 12 and above give sworn evidence. So this is what happened previously. So that's why previously determination of the competency of a child and whether the child should give sworn or unsworn testimony is made on case by case basis. Okay?